はじめまして、イセルン特許商標法律事務所の前田と申します。イセルンはスペイン・バルセロナに1924年に設置された知的財産事務所です。現在スペイン国内に12の事務所を持ち、約150名以上のホームスペシャリストにより、スペイン国内や欧州域内をはじめ、全世界のクライアント様の特許、商標、衣装の権利保護をはじめ、模倣品対策、侵害訴訟などといった知財案件をサポートさせていただいております。また、イセルンがスペイン語圏の事務所であることより、長年にわたり、中南米各国の事務所様とつながりも強く、諸各国への知財サポートや法務情報をご提供させていただいております。アジアからのお客様により緊密に対応させていただけるように、5年ほど前よりジャパンデスクを弊社内に設置いたしました。日本の知財事務所様やクライアント様のご事情をより理解し、メールやビデオ会議といったコミュニケーション手段など、日本のクライアント様からのご相談に対応させていただいております。この度、弊社アナカサス弁護士より、3D 商標と衣装といった様々な登録方法により、商標の保護法につきご説明させていただきます。どうぞよろしくお願いいたします。
Hello everyone, I'm Ana Casas, an IP lawyer with more than 20 years of experience, and also I'm teaching at the university in IP matters and trademarks, designs, all that stuff. I'm working in ISERN, Patentes y Marcas, a huge company and the leading one in Europe about IP portfolios, and I'm handling different projects around the world together with accompanying the client and developing their projects in IP area. So we are protecting a lot their new products and new campaigns, everything. And one of the figures that are the most important in this field is the 3D trademarks and the industry and design. So that's why we are here, because we are now going to focus our attention to these two legal figures, and to examine their requirements. Let's see. Okay, trademarks. The legal definition is that the trademarks, besides having a usual marketing requirement, they have to have two functions. The first one is to individualize a product in the market. Like you have two pens, and the only thing that allow you to differentiate these two pens is the brand that it's printed on them. So like Stadler and Alpino, the two denominative trademarks are in the pencil, and we distinguish them for the name. But the mark also has another function, and a legal requirement is that he has to be capable of identifying the company who markets it in the market. Okay? So this concept is ruled in the Article 4 of the regulation in the EU, and these two functions, they are the legal requirements that we cannot escape from. If you want to register one trademark, you will have to accomplish both of them. So, from the marketing point of view, a trademark is the symbol for the customers, and they are going to pick you because of this symbol, okay? It distinguishes your products, your quality from the competitors, and it individualizes you also. Your notoriety, everything for you work for is the brand. The brand contains all the message. So the brand in all the countries is registered, but there are some that they allow you. They give you some protection if you are using it before registering it, like common law territories, UK, US, all that stuff. The only thing that we have to take into account before registering one trademark is the absolute grounds. The absolute grounds are contained in all the rules. They are legal prohibitions of one trademark cannot be incurred, like be descriptive, a direct description of the product. For instance, I don't know, boot tables for marketing boot tables. that would be not allowed as a trademark, okay? Or burger, which is a usual common name, despite being an English name, we are using it in around the world. So this word has not distinctiveness enough to be a trademark, okay? There are different and several absolute grounds that we are not paying attention now, but there are a lot. So here we have it. Also, some rules are against the bad words, contrary, the words are contrary to the public policy, all that stuff like the brand marijuana that someone intends to file, or the geographical indication also that they have been a lot, it has had a lot of issues in that area recently because of that, because a lot of people wanted to use champagne in the champagne field, but you cannot say champagne because it's a geographic area and it comes from France, etc., etc. So we have several particularities to pay attention before filing a trademark. The legal concept of the trademark, as we have been told, has some exceptions, and the exceptions are given from the use. If you use a trademark intensively in the market and you put the brand in every advertisement, you put the brand in all the websites, everything, it turns out you're giving it a lot of distinctiveness. We have put two examples in this slide, like diesel, which of course has one meaning and it's for covering clothes, or Apple Wallet, which is a nonsense denomination, but everybody knows that it's an electronic application for putting your credit cards. So the use, again, is the one who is giving the trademark its distinctiveness. So now, once we have our brand and we are capable of distinguish some products, and we are capable of identifying the company who is marketing the products, then we have the exam of the absolute grounds, and we know that it's not a descriptive, it doesn't go against public policies, blah, blah, blah. Now we have to focus in the prior registrations. It could be that if you want to trademark Levi's for clothes, that this brand pre-exists. And if one brand pre-exists, he has to have two identities to be an obstacle for the new application. It's the identity or similarities in the denomination or in the appearance, the graphic appearance, and then the identities in the covered products or complementary. So we have put this kind of example. Samsung is a well-known trademark, for the electronic and television area. So if I'm filing the trademark Samsung for the same, of course I'm accomplishing the two requirements: similarities in the denomination and coincidences or complementarity for the products. So Samsung could file an opposition and probably it will win because of these two requirements. But we have this one, and this example is a really good one. So the denomination is the same, the graphic representation is different, but these two trademarks can coexist because they are covering different goods. One is for handbags and perfumes, and the other one is for televisions and electronics. So they are never gonna find each other. They are never came across in the market. However, both of them have been marketed a lot with an intensive campaign, both of them. So both of them are well-known trademarks and both of them are strong. That's why we know them. But in the anonymous world, two trademarks with the same denomination, but in different areas, they can coexist. That's the law. So when you file a trademark, as you may know, you have to designate the products or services you are going to cover with it. The intended products can be from 1 to 34 classes, and the intended services goes from the 35 to the 45 class. okay? We can file one trademark for different things, 1 class, 2 class, 3 class, or just for one, okay? So the classes thing is the important one because they allow us to coexist with similar trademarks since we are in a different area, as we have seen before. So I put an example here of pharmaceutical products include in class 5 and a cosmetic include in class 3. The name is similar, but both of them are sold in different channels of the market. They are never going to find each other. They are never came across. So the International Property Organization has granted the mark in class 3. So there are different concepts of trademarks and typologies, of course, depending on the point of view you are analyzing them. Territorial point of view is the most important. It's obvious that the trademark is territorial. It covers always one market or accumulation of markets, but it's our national trademark. You are registering it for one market in particular. You can do a Chinese national trademark, Japanese national trademark, Spanish, Japan national trademark in every country. You can also file a European Community trademark. Then you can go with one mark and file an international trademark. The international trademark is ruled in the Convention of the Union of Paris. This rule is that if you have a national brand, you can file its internationalization in the WIPO, the International Office of IP. So they allow you to file the same brand with the same owner and the same denomination and class. You can extend it to different territories. And this is an international trademark because they recognize each other, the countries, so you have to pay less tax and official fees. So that's a benefit for the applicant. The counterpart of that is that you have more time, you require more time for having the granting of the trademark. And finally, we got the foreign trademarks. It's the same as the national one. So if I'm here in Spain, for me, a foreign trademark is going to be a South African trademark or a UK trademark or a Japanese one. For the point of view of the typology of trademarks, its nature makes them as verbal trademarks, like Bioramina, iPhone, and other ones. The figurative trademarks, it comes out that they are formed by a denomination and a device, okay? And the device become as important as the denomination in the whole brand. So that's why we call them figurative. The graphic, it's that they are only composed by just a graphic thing. And the three-dimensional brands are the ones that are composed by denomination, graphic, and also a form, the form that they are presented in the market. So recently, an EU rule has compiled the new typologies of trademarks. The typologies of trademarks are trademarks ruled in the European law that try to cover the new appearances in the market. So the market has a lot of sounds and the market has a lot of electronic things that are brand. And until now, we didn't have the tools to cover it, okay? Like, for instance, the hologram marks are the birth of the Visa card. Until now, we haven't the chance to cover it as a trademark. And of course, it's a trademark because once you see the birth of Visa card, you know that it's a Visa, you know that it's a credit card, and you know where it's come from. And you can differentiate it from another credit card. So it's a mark. And until now, we haven't the chance to cover it as it was. So now we are we have finally this tool, but we have to pay attention to the olfactory and taste trademark. These two kind of trademarks requires some kind of subjective criterion. So the taste trademarks for me are a mystery, because as a consumer I have to taste the product before knowing if it's a trademark I want or not. They mislead, at least to me, how we are going to work with them. And the olfactory happened the same. For instance, maybe for me, one product smells like, I don't know, roses, and for my neighbor, it smells like lemon. And this is subjective, or strong subjective point of view of a trademark. I don't know if we can put in a neutral part, but here they are, so let's try to register some one of them. Now, the process of registering one trademark is really, really easy, but it's the same around the world, but with different timings, right? In Europe, we have the filing date, then the absolute grounds are examined before the publication, and the trademark is published 1 or 2 months later after the application. Then this publication opens the 3 months period for filing an opposition. If no one files an opposition, then the trademark is going to be granted because it has already been examined by the examiner with regard to the absolute ground we already discussed about. If someone files an opposition, you have to file a writ of defense, insisting in the compatibility of both trademarks, and then the opposition has no reason to be. Okay? Then there's in Europe it open like a period that you can do allegation, contra-allegation, allegation, another allegation, until the examiner said, okay, enough, I got all the information, I'm going to issue a decision. And then the examiner issues a decision. It grants or denies the trademark we are filing. So now we are talking about the industrial design. It's a legal figure. It exists before, and it covers the appearance of the whole part of the product as you are marketing it in the market. So if I have this kind of thing in the market, the design is going to cover everything. So this part with the hole, and then the lateral part, and then this other one. And I'm going to file before the European registration, for instance, 7 pictures with all the visual content that the consumer is going to find out in the market. Okay. We have 3 kinds of industrial designs. Okay. The first one is the 3-dimensional design, which covers always the shape of the product you're going to show in the market. Okay, you're going to market there. So our recommendation is to file it together with 7 views of the product that show the vertical lines, the horizontal ones, the impression that the consumer is going to have. You're going to show the downside, the upper side, the holes. You're going to show everything. If you don't show the particularities of your design, the register is going to be useless, because the originality of your design is the one that this figure is going to cover it. So we require all the information there. We have 2 more types of designs. The first one is the bidimensional design. It's the one which is similar to the trademark, the graphic trademark, which is composed by a graphic and a denomination. However, it is treated like the ornament of a product, the shape of a product. It has not the requirement of distinguish one product from the other. It has not the requirement of identifying the company. You can put an ornamentation and you can register it as an industrial design. Okay, and the third type of design is the more common in the market. It's the one which it's conformed by the combination of the prior ones, the graphic and the bidimensional design. So you have it the more we are used to register it, because in the market we have this combination of elements. So the consumer is going to come across with that, and this is the shape that we're going to cover, the shape with the ornaments, the colors, and everything, the whole package. So an industrial design is in force during 25 years, and the owner has to pay every 5 years one official fee. So as the trademark, an industrial design could be national, international, EU, in the EU or other countries, okay? So it's the same criteria, the territory, and you can extend it even in the before the intellectual property worldwide registration as an international design in. You have one registration, one local one, and then based on this registration, you can file the internationalization of this design in another territories. So the particulars of the designs. So the design, as I told before, has to show all the faces or forms that it's gonna show in the market, okay? In the right side, you can see clear blue in different colors with the shape right and colored in different ways. Why we do that? Because if I create one design, like a chair, and the back of the chair is rectangular, I'm gonna file a design with different variants. The chair with a rectangular back, the chair with a round back, and the chair with a triangular back. Why? Because my competitors, they are gonna see my chair, the original one. It's a rectangular back. But in order to avoid an evident copy, I'm gonna file together with the rectangular shape, the round and the triangle. I'm putting some obstacles to the competitors to copy me easily. They have to work to copy me and to create another different design. In this case, my chair is gonna have different covertures, different protections, so they have to be more imaginative in order to copy my chair. And that's why Clear Blue did all that stuff, and the graphic representation of the bottle, it's really accurate because, as I said before, we need to protect it in every kind of point of view. So we have detected recently double registrations. Companies are using trademarks and designs to cover all their marketing and creative work. So imagine the first one we wanted to point out is the ornamentation as the UE design of the cleaning product. Sorry. And the same ornamentation has been registered as a community trademark, as a bidimensional one, and both of them, they are in the market. But both of them, they are covering different aspects of the same product. The first one is covering the shape, okay? The consumer is going to identify this design, and this design is going to be with the brand. It's going to lead him to the brand. But this is a design, this is a form that I'm, as a consumer, I'm going to see, okay? The brand is notifying the consumer, the company who is marketing the product, the brand allows the consumer to differentiate this product to another similar one of the same type, etc., etc. So we have pointed out different registrations they belong to the same company, and they are different. They are or designs or trademarks covering the same object. So arrived to this point, and after saying everything we have discussed here, what do you think that the washing machine, the bottle, or the candy are registered with? So I'm going to tell you. At some point, I disagree, but this is it's what they have registered. So the washing machine is a design, of course, because it's the form that the consumer is going to receive. The bottle, instead, despite being the form that the consumer is going to receive, it's a trademark because as we mentioned before, we can file a three-dimensional trademark showing all the forms, colors, and devices it contains. Okay, and the candy form, instead of being a device, it's also a trademark. Why? We are going to explain it later because this is a strategical commercial tool that's really useful. I'm going to tell you why. So the same happens here. We have two watches and they have been covered in a different ways, and we have two cars and they have been covered in a different ways. See that? The first watch is an industrial design, and of course it is, because it's the form, the shape that the consumer is going to see in front of a watch, okay? The second one, instead, it's a trademark. Why? Because the trademark never ends. You can renew it, and renew it. And the EU design, or every design, it has the life of 25 years. And after that, it became public and everyone can copy you. So the companies are doing that, registering the same object as trademark in order to preserve it forever. The car, the mini car, it's amazing, but it's covered as a trademark here. In this registration, I agree that it's a trademark because despite being the form of a car, it became, with the intensive use, as we talked about before, the intensive use converted in a trademark. You see the car and you can go to the brand. So it's okay. And the last car is an EU design, as we have to register a car. And here we have some exceptions with the intensive use compared to products that are an eminent design. They convert it in the trademark, as I just said now. For instance, Tiffany's box is a box. It's an industrial design, and it's a common box. But because it has this kind of green color with the Tiffany on it, it turns out it's a trademark and it's a well-known one. The same happens with the Lego piece or with the lean bonbons, everything. It's a notorious, well-known trademark. So the design loses here to give more space or more room to the well-known trademarks. So in this case, I wanted to insist in the importance that we have this kind of tools, the designs and the trademarks, okay? And these tools are gonna, of course, they protect our inventions and our creativity, but they are gonna change, and one has more importance than the other one, depending on the use we're gonna give to the product in the market. For instance, this kind of bonbons are really well known now. With only the visualization of the bonbons, you know that Lean is behind the chocolate. You know the quality of the chocolate. You know the service of the owner. Blah 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 blah. So the design became a mark. So in real life, what can we protect? So in front of a product, like a slot machine or the gum, the glue roller, we can protect them with several tools that the law actually give us. For instance, the trademark that they include in their shape, one is Thirsen, the other one is Prit. Both of them are registered as a trademark. Then they contain a specific design, the shape of the product that the consumer received, it's also covered as a design. Then Henkel also has another design, which is on the top of the roller, and it became really distinctive because the other rollers, they don't have this kind of three lines that make it particularly distinctive. Then the slot machine also has a special button that it turns out it has been a utility model because it doesn't exist before, and it also includes some improvements in the sector. So that's why we register it as a utility model. And that's another industrial design. This is, of course, a cook for cooking. This is a tool for cooking. And it has been protected through a utility model. it puts container with top for cooking food stuff. It's the official definition of this product, okay? This container of cooking also has a specific shape that has been covered as a design, okay? Everything relays on the same object. And then, sure, you can put this next one, okay. We have another container registered as industrial design that has been really well-known container here for years in Spain. And its owner has registered it as an industrial design because he said, I don't want that for life because I know it has an end. You know, he put the product in the market, he's gonna hit the market, and then the product is gonna die. So they don't need the design, they don't need the trademark forever. They only need the design in this case. The differences between these kind of signs are really easy. The 3D trademark covers the distinctive character of the sign. So it allows you to individualize it in front of other similar products, like the pens we discussed before, Alpino and Stadler. You have them there, and you can differentiate them for the trademark. Instead of that, the industrial design covers the appearance of these pens. One is really straight and with some lines in the design, and the other one have a specific shape with one eraser on the top, whatever. So these are the designs, okay? The trademarks, of course, requires distinctive character. They have to allow the consumer to differentiate and individualize the product. The industrial design only requires novelty. So you have to take into account before registering one industrial design, you have to keep it in secret, and then you have to register it, and then you can do whatever you want in the market with the design, but not before the registration, because legally we require the novelty. And the trademarks also have no limit of the time. You can have them forever. You can pay renewal fees, and you always have them in force, and they give you the protection of or the shape or the label of the product, whatever. The industrial design have legal effects maximum for 25 years. You have to pay 5 years tax, but at the 5th it ends, and so your design became public and everybody can use that shape in the market. So the trademark or the industrial design is nowadays the two tools more used for the huge company, because they, as we said before, they decide if the product is going to be launched in one point and the product is going to be for 3 years in the market and then it disappears. So they decide to register a design, an industrial design, or it's a trademark that they intend to be the main one, and then the main one of a family of trademarks, whatever. So they decided to register the shape as a trademark instead of a design, because it's gonna die in 25 years. So I love this brand because Louis Vuitton is doing with an accurate criteria the registrations. Of course, a bag and its shape. It's a industrial design, and it's perfect, this registration. And nowadays we have the pattern brands. It's this kind of brands that allows you to register the pattern that you are marketing in the market. Okay, so in this case, they are really accurate with this kind of tools, of legal ones, and I love them because they are doing very well. Toblerone, it's one of my favorite chocolates also, and with the time they have updated their registration. So they never registered a design. They also focused in the brand, because with the time, they get the well-known character of the chocolate based on the form of the shape of the product. Okay, these triangles all together, you have to separate them, all that stuff. So the main and the important trademark in this case is the one in the middle, because it's the whole business. And also with the time, the packaging of the product also became well known, because it's the only package with the triangle form, it's a shape, a specific one with the brand on it, it's a red one, you know, all the combination of the elements, the colors, the shapes, and the design allow the company to be well known. It's unique and it's really good, the marketing operation they did that. And soaps, for instance, we have been focused in the, you know, this kind of soaps in the market. At the beginning, they were industrial designs. But now, because of the combination of the colors, the shape, and all that stuff, you go to the market and you can differentiate them only for these colors or only for these shapes. And that is the work of the trademark, not the design. The design only has to cover the shape, and the mark has to allow the consumer to differentiate one soap to the other one. And in this case, you can differentiate the soap because of the shape and the colors. So now these registrations are really okay because these are brands. Raise of registration, everything as 3D trademarks. Okay. As we have been told, the companies, they have to take into account the absolute grounds of everything before registration a trademark or before registration a device. Okay. What happened with the 3D trademarks? They have to have distinctive character and they have to identify the company or who is marketing them. Okay. So in this case, one client intends to register as a trademark, a 3D trademark. It was a lamp. Okay. What happened there? The examiner said, I'm not gonna grant it this registration because this is an industrial design. This is a lamp. And the consumer is gonna see a lot of lamps with similar forms, similar shapes, similar colors, and per se, it doesn't help the consumer to differentiate this specific lamp from the other ones. So it cannot do the function of the trademark, so I'm gonna deny the trademark. And that's why we put it here, because it's a big example of what's going here. We have to be accurate in the form we choose to protect our projects. Yeah, since international, national, and community laws allow the registration of the 3D trademarks and the industrial designs, they have been in conflict a lot because we put them all in the market covering the same product, and the examiner at the end, it's the one who has to evaluate if they could mislead the consumer to think about which company is coming from this product, or this is not the same quality as before, or all this kind of stuff. The examiners, they have this responsibility every time they examine a trademark, okay? So we wanted to put this case law we came across with 2 years ago. The applicant filed, it's the bottle of the gray bottle. It's the applicant that filed the cancellation, okay? Because he considered that the bottle filed as a trademark was infringing his design. He said that his design has these 3 lines in vertical and the other bottle has the same lines, and the shape was similar and the label was in a similar position down in the bottle. So the examiner and in this case the European Register said, I'm not going to cancel that because it's a trademark, it's not a device. So the device maybe has more possibilities of colliding with your prior one, because a device, it's always depending on a line, on a shape, and all that stuff. But we are talking about 3D trademark, okay? In this case, the 3D trademark is colored in pink. It's presenting with one level, and it puts the name of the company, so it's not colliding with your device. What is the sentence said? So again, when we build up the protection of one project, we need to be really accurate about what's going to be in the market for how long and how we can use these tools to protect our product. In this case, the design couldn't fight against this bottle, that it turns out it was a similar one, but the shape was also thinner, and with the differences of the color and the label, the examiner said, okay, this is a brand, and it's not colliding with you. So that's it. We have all our presentation and all our recent cases about 3D and design. And if you want to set something or discuss about some point, you have here our email, and we will be pleased to advise you. So thank you for listening to me, and hope to see you again. Bye.